The Supreme Court is hearing a major challenge to the Voting Rights Act. Louisiana v. Calais centers around the state's congressional maps. Back in 2022, a group of black Louisianans argued that having just one black majority district limited their voting power. They won that case and got a new map with two majority black districts. Well, now a group of non-black voters is arguing the new map discriminates against them.
Joining us now to talk more about the potential implications of this case is the Hill's legal guru, Zach Schoenfeld. Zach, thanks for joining us. A huge case. Really revolves around Section 2 of the Voting Rights Act. What does that section entail and what's at stake?
Hey, good morning, Corey and Hillary. That's right. This is really a big day at the Supreme Court. This case stands to impact not only the future of Louisiana's congressional map, but voting maps that have been enacted all across the country. The question before the Supreme Court is, can Section 2 of the Voting Rights Act continue to force states to draw these additional minority-majority districts? As you just went through their history in Louisiana, this has happened in a lot of other states too. And the argument that Louisiana will make today is backed by the Trump administration, is that courts have been stretching Section 2 too far, to the point where it's now running into the Constitution, the 14th and 15th Amendments that provide equal protection under the law and prohibit intentional racial discrimination in voting. So essentially the argument is that Section 2 has went too far to the point where it's now an unconstitutional racial gerrymander.
So this is a bifurcated case, right? It starts in 2022, and at that point, Louisiana agreed with the idea of having a black majority district, an extra one. State was with the people who were suing, and now the state has flipped. Now they're choosing to join hands with the non-black group that believes it's discriminating against them. And what's the legal argument they're using?
So this is now actually the second time that this case has been argued before the Supreme Court. As you mentioned, the first time Louisiana was on the opposite side here. And the argument they've made is they said they've never truly given up their position. They said they never really believed that they had to draw the second majority black district, but they basically accepted that they lost that part of the case. And so they just accepted that we needed to draw a second majority black district. They were very concerned that a court was going to take over the process. They were concerned that a court was going to draw new maps that potentially would draw out Louisiana's high-profile Republicans, people like Speaker Mike Johnson, Steve Scalise. They also have a member on the Appropriations Committee, so they were concerned about that. But now that they say that the Supreme Court is actually rehearing the case, they've really raised the stakes, raised this new question that really asks about the future of Section 2. That's why you're now seeing Louisiana go and flip back their position and say, okay, now we'll come back to what was really our original position, which is that we shouldn't have had to draw the second district in the first place.
So there's two cases that we can look back on to maybe tell us what the Supreme Court might do. Shelby v. Holder is one of them, and then Allen v. Milligan. How did those cases play a role here?
That's right. I'll start with Shelby County. This was a case about a decade ago in which the Supreme Court struck down another part of the Voting Rights Act, a part that had required certain jurisdictions with a history of discrimination to get pre-clearance before passing new voting laws. The Supreme Court about a decade ago said that that was no longer constitutional, that we've essentially made enough progress, in our country that we no longer need those measures. So that's a similar argument that you're now going to see try to be applied today to Section 2 of the Voting Rights Act. So that's Shelby County. Now, you mentioned the Alabama case a few years back. That was another Section 2 Voting Rights Act case, and it came out being 5-4. Justices John Roberts and Brett Kavanaugh actually joined the three liberal justices to create a majority and strike down Alabama's map under Section 2 of the Voting Rights Act. It took a lot of people by surprise. So now the question becomes, will Roberts and Kavanaugh do the same thing today and line up with the liberals and give some of these black voters what they want?
And here we have Justice Brett Kavanaugh talking about this Alabama case, Allen v. Milligan. He said Alabama did not raise that temporal argument in this court, and I therefore would not consider it at this time. What is he talking about there?
Yeah, that's back to the Shelby County idea, this idea that we've come far enough as a nation, we've made racial progress that we no longer need these measures on the books. And like I said, that's an argument that's now being made about Section 2. It came up in that Alabama case a few years back, but as you heard in the quote there from Justice Kavanaugh, Alabama wasn't actually raising that before the Supreme Court, so the Supreme Court didn't really address it. But a lot of people have latched on to that cryptic comment from Justice Kavanaugh saying, I'm not going to consider it right now, but perhaps maybe if someone brings it in the future, I will. And of course, today now, Louisiana will be bringing that argument. So the question becomes, will Kavanaugh give that argument some weight today?
Zach, if ultimately the Supreme Court decides to further disembowel the Voting Rights Act, how will this impact not just Louisiana, but the broader states?
It could really throw into question these majority-minority districts that have been drawn in places all across the country. You see a lot of these in states in the South. We've talked about Louisiana, we've talked about Alabama. There's been cases coming out of Arkansas, but also, cases really all across the country. There's Section 2 Voting Rights Act cases that have been brought as far as Washington State. So there's really these districts all over the country. And, depending on how far the Supreme Court goes here, there's lots of ways that Louisiana could win. They can win narrowly, they can win big, and potentially if they win big here, it could really throw into question the future of all of those other majority-minority districts.
So the organization Black Voters Matter says up to 30% of Congressional Black Caucus and 11% of Congressional Hispanic Caucus members could lose their seats. Real quick, would it be folly to look at the decision in the affirmative action case and say they're probably going to rule the same way here, that, they said affirmative action was somewhat discrimination against white people, Asian people, and say that here?
This certainly is a follow-up to the affirmative action case. You actually see that as you read the briefs in this case, is that affirmative action decision is written all over the place. So that is something I expect to be front and center at today's arguments.
All right, Zach Schoenfeld, our legal guru, thank you so much. Appreciate that. And you can always read Zach's reporting on thehill.com. A new edition of The Gavel will be dropping at 8 a.m. You don't want to miss it.